What's up, everybody? And welcome back. We're at it again this afternoon. More stuff happening. We were going to talk about just the potentially planted DNA evidence, or at least allegations of such, in the Kohberger case. And then the alibi notice was filed. It was actually filed yesterday, July 24th, which was the deadline. So we're going to look at that and discuss that. That's actually very, very interesting, and a lot of different things you can take and learn from that alibi filing. So we're going to get to that. But first, it's going to be the DNA evidence, the allegations of it being planted. I want to answer your questions there. I want to go through what you think about it, because it's really going to come down to a lot that we still don't know, but whether or not it is potentially material to the defense. And that's really what I think is really important about this discussion. So before we jump in, hit that like button. So anybody else that's out there that's waiting on this video, it'll pop up on their homepage on YouTube so they can come and join us as well. So we can kind of talk through these two major Kohberger issues together. Oh, and then at the very end of the video, for anybody that wants to stick around, we are going to announce the winners of all of those 250K subscriber giveaways. I've got a full list of everyone's name that won. So if you want to stick around, if you tried to win any of those, if you're a subscriber, then you had a chance to win. So let's get to it here. So where did we even get to this potentially planted DNA evidence? Well, it's been referenced in some of the filings, so I want to bring one of them up. This is the reply in support of the motion for protective order. The state trying to protect or stop Kohberger from getting some of this DNA evidence, specifically the IgG information and how they built the family tree and how they got to Kohberger with the DNA. So let's read this paragraph first to start. As best the state can tell, the defendant is not asserting that B or C apply to the IgG information, and B or C reference above. This is the only way they can get the information. A are material to the preparation of the defense. That's the big question we're trying to answer. B and C are intended for use by the prosecutor as evidence at trial. Seems like they're not asserting that. And even if they were, the prosecutor is saying categorically that is not true. Or C was obtained from the defendant or belonged to the defendant. Doesn't seem like they're asserting that either. I would agree with the prosecutor. The main argument for the defense is that this is in fact material to the defense. Therefore, presumably, then the defendant was attempting to show how the IgG information is material to the preparation of his defense when he asserted that someone other than the defendant may have placed his DNA on the K-bar knife sheath. So just that statement alone, which they cite the actual objection there. Someone else may have placed the DNA there. We know it's touch DNA. We know it can be transferred from person to person or object to object. We know that Bryan Kohberger went to a nearby school. We know that he is in school even though he is older. We know that this is a party house. We know a lot of people in and out. Okay. So with all of that, I don't think that it is out of left field for the defense to argue that the DNA got there some other way than Bryan Kohberger. So the word placed, I think, has a certain intent behind it, but I can place something down or accidentally place something somewhere, so it still could potentially be an accident. All right. And that is referencing their actual objection at page 4. So that to me doesn't have necessarily a nefarious implication that the touch DNA could have gotten there some other way than Bryan Kohberger, which is true. It could have. Not saying it did, but it could have. But the state is at a loss as to how that theory supports a claim that the IgG information is material to the preparation of his defense. The SNP profile used in the IgG was created from the same DNA used for the STR analysis, and the state is providing the SNP profile and information related to the STR analysis and discovery. So it's like, it's all the same, Judge. Well, if it's all the same, why aren't you producing this? Because it's not all the same. If the defendant, and then here's the last sentence, if the defendant wishes to explore the theory that his DNA was planted on the K-bar knife sheath, he is free to do so. But the family tree created by the FBI has no relevance to that theory. So I have a lot of thoughts on this. First off, DNA planted. They didn't reference specifically where Kohberger's team said that. But they do mention that this may be a theory Kohberger's team may be going under, that this DNA was planted on the K-bar sheet. Now, it doesn't say that it was planted by law enforcement. I'm going through in my head all the questions I have, all the things people are asking me, basically boil down to, did law enforcement plant Kohberger's DNA on the sheet? I don't even necessarily think that's being said in this motion. It was potentially placed there by who knows or what, or it was planted there, again, not specifically by law enforcement. Could have been he was set up or somebody else there, or he was the driver even, and they wanted to pin it on him. So a lot of unknowns, right? But if it was placed there or planted there by law enforcement or someone else, if that is the theory of the defense or one of the theories of defense, we're getting pretty far down the road as to why the IGG and the family tree created, in my opinion, would at least be material to the defense of the discovery period. That does not mean it's admissible at trial. But if they are going to with a theory that, let's just say law enforcement planted the DNA, because that's the question I've gotten the most. If they are going with that theory, if law enforcement started the family tree with Kohberger and worked backwards, that could be material. If they did 15 family trees and not just Kohberger's, that could be material for a number of reasons. Number one, to show they weren't just focused on him. Number two, to show there might be some other suspects, which they do argue. But was Kohberger the trunk or the roots or whatever it would be, or was he a branch on the family tree based on some unknown profile? Or was his name put in first to build this family tree? Some of this information can come out in depositions. Some of it can come out in some other documents potentially. But if they're saying it was planted, if they're saying they targeted Kohberger, if they're saying that they wanted to make sure they got Kohberger, then how the family tree was built could be important. Could be. Which is why it should be discoverable. My opinion. They make arguments that you don't get everything in discovery. You don't get everything done in an investigation. And that's true. And I got the question, well, can't the defense just say anything is their theory of the case, having no reason to actually believe that? And then they can get more investigation information and more discovery. Well, the defense has to actually have a good faith basis and a reasonable belief that this could be true or this could be part of their defense. Okay, so they can't just say it willy-nilly about anything. And when we're looking at this, what information do they have that potentially could make this a reasonable belief or a reasonable argument? Well, we have heard that there's no other Kohberger DNA anywhere in the apartment or on any of the victims. We have also heard that there's no victim DNA in Kohberger's house, car, or any other place Kohberger was. We've also heard there's no connection to Kohberger and the victims. Now, none of those things make this crime impossible to be committed by Kohberger. That's happened plenty of times where there's no seeming connection and they end up committing this kind of heinous crime. But if they're saying he's never been there, there's no other evidence of it, this is the only piece, and the reason this is the only piece is because it was planted, that is leading down the line of at least having a good faith, reasonable belief that this is a real possibility, and therefore they need to discover potential evidence around that theory of defense, which would make it material to their defense. Bodie, Peter, where would they get the DNA from him to plant it? That's a great question. Which is why I think timing of the family tree is important. What did they have at that time? What did they gather? It's very interesting. Like the DNA stuff is very weird because it is the most damning piece of evidence. It is something in the probable cause affidavit that they said, even without this DNA analysis, we still have enough for probable cause. It's very strange. Who planted it is the $1 million question. Yeah, we may never know because maybe nobody planted it, right? Patrick, happy Tuesday. Peter and the Lawyer You Know chat. I've missed y'all lately. Missed you too, Patrick. Amber Am, why would they pick him to plant it? Another great question, Amber. Another great question. I have no idea. Maybe, so the only thing I could think is potentially there is pressure from the outside and the victims to get somebody. Maybe they found out he drove the right car in question and somehow they got his DNA or something was in the system, which it seems like it wasn't. and planted it. But I agree. I think that's a great question as well. And that's something you better believe the state's going to bring up if this is something that the defense wants to go with. Welcome to Sid and all the new members today. Melstar, anyone watching this Shaw business trial? I have watched some of it. And actually, I am doing a video tonight on it that's going to post. That's going to talk about what's happened in the trial so far and dive into deeply and answer a lot of questions about the two pleas, the two phases, the not guilty versus not guilty by reason of insanity, the differences, why it's set up like that, how different it is, if it is different from other states. So hit that subscribe button and the bell to remind you so you don't miss any videos we post. Okay. So let's get into the alibi now. Okay. So now the alibi was due July 24th. And it was reported that all of the grand jury information was going to be produced on the 21st. So that means they would at least potentially have information on the grand jury and those proceedings before filing their alibi. As we know, the judge granted an extension of time for Kohberger to present his alibi until the 24th. Again, more time to gather more evidence, more discovery, more DNA information, even though he didn't get it to this point, and even the grand jury information. So they know what evidence the state presented to the grand jury at this point, I think. So let's take a look at the alibi that was presented. So this is the defendant's response to the state's alibi demand, because the state had to demand it to start this clock. Kohberger, by and through his undersigned counsel, hereby files this notice in response to the demand for alibi in compliance of Idaho Code 19519. So again, this does not say this is his alibi. This says this is his response to the state's demand for his alibi. Mr. Kohberger notes that Idaho Code 19519-4 preserves his constitutional right to silence as well as to testify on his own behalf. We're going to pause here, jump over to the Idaho Code 19519-4 so that we can see exactly what that says and how it may come into play here. Now, it's kind of hard for you to read, so I'm going to read it for you. And it's paragraph 4. This is the notice of defense of alibi, okay? So paragraph 4, upon the failure of either party to comply with the requirements of this section, the court may exclude testimony of any undisclosed witness offered by such party as to the defendant's absence or presence at the scene of the alleged offense. So what does that mean? That means if Bryan Kohberger, in this notice and response to the alibi to the state, if he does not produce the documents, the materials, the witnesses, and their testimony that are going to support his alibi that he was not there at the time of the offense, at the location where the offense was committed, if he does not produce those by July 24th, by the time of filing this notice of alibi, then the judge may exclude. He may exclude those witnesses. Doesn't say must, but may. And I believe judges would allow it later, even though some people think that's unfair. But if it's a legitimate alibi and a legitimate witness that comes forward and be like, no, I saw Bryan Kohberger walk out of his apartment at 8 a.m. that morning and he was there the whole time, whatever. You know, if some witness did come forward, I still think because this says the judge has discretion to allow it, that they still would. But at this point, the judge may exclude. However, the point referenced by Kohberger, this section shall not limit the right of the defendant to testify in his own behalf. So that right there, I think, is the part that Kohberger and his team are focused on. So we're going to jump back to their notice of alibi. And where it says he preserves his constitutional right to silence, but also to testify on his own behalf, because regardless of what they say at this point, regardless of if they provide an alibi, the judge can block certain evidence of an alibi at this point because he didn't bring it forward. However, he is still allowed to testify on his own behalf. And why is that important? Because he can still take the stand if he wants and say, I wasn't there, I didn't do it, I was at home sleeping. That is technically an alibi that technically the defense has not noticed the state on yet. But because it's the defendant testifying, there is a carve out and an exception in the rule that they can still make that argument based on his testimony. And more. Mr. Kohberger stands firm on his constitutional right, as well as the statutory recognition of that right. Noteworthy is that an alibi, quote unquote, indicates a line of proof by which the defendant attempts to show that he could not have committed the crime of which he is accused because he was elsewhere at the time. A defendant's denial of the charges against him does not constitute an alibi. But as soon as he offers evidence that he was at some other place than that where the crime of which he is charged was committed, he is raising the alibi defense. So again, this is something that could potentially be blocked or excluded if you do not notice the state in the time period. Mr. Kohberger's defense team continues to investigating and preparing his case. Evidence corroborating Mr. Kohberger being at the location other than the King Road house. Sorry, let me try that again. Evidence corroborating Mr. Kohberger being at a location other than the King Road address will be disclosed pursuant to discovery and evidentiary rules, as well as statutory requirements. So they still think they have certain things that prove he was not there. So it is also anticipated that this evidence of alibi, may be offered by way of cross-examination of witnesses produced by the state, as well as calling expert witnesses. What does that mean? Are they going to have expert witnesses come and testify to an alibi that Bryan Kohberger was somewhere else? To me, I think all this means is we're going to be able to prove through cross-examination and expert witnesses that Kohberger was not there. That touch DNA was planted, or it's not enough, or whatever. There's no other DNA. He couldn't have done this. He didn't have the knife. It wasn't his car, whatever. They just think through cross-examination and expert witnesses, they're going to be able to prove he wasn't there. Feels like a nothing burger and stuff we already know. But it also seems like they're not going to produce an alibi at this point, but they are still going to argue he wasn't there, which is fair. And this is how they can do it. Cross-examination, expert witnesses that, that's not his DNA or whatever, it was planted, whatever they're going to have an expert say. And then, of course, Kohberger's testimony itself, which we've been saying all along. If he is going to get up there and say, I wasn't there, that is not what becomes produced in a production of an alibi or notice of an alibi by the defendant. That would be, my wife was sleeping next to me the whole time, holding my hand. She knows I didn't get up. I have an alarm system. It beeps every time my front door opens. Check my alarm system. No beeps, no openings that night. I drive a Tesla and it shows it was parked outside my house, plugged in and charging, whatever. That would be corroborating evidence of an alibi that you were at your house somewhere other than where the crime was committed. So, no alibi outside of just the normal defense of a case. Not surprising, but interesting because they asked for more time and the judge allowed it. So tell me what you think about this. Does this change the way you think about the case? John, do a poll. Did you expect Kohberger to produce an alibi? And we're going to mean an alibi in addition to his own statements. So a poll. Did you expect Kohberger to produce an alibi? I just want to know kind of where the chat stands on this. Ashley asked, can you look into the Karen Reed case? I don't know anything about it. I have gotten a lot of requests for new cases, though. Jamie, I'm still believing that the upstairs victims were killed earlier and closer to the 4 a.m. The others were K. I don't know. I feel like in this case, I find myself saying I don't know a lot more than many other cases. Trial time, Tammy. Where can I find the day in the life video, Peter? So all of this stuff has been a little delayed. We did play a teaser to the golf video, which I can play again at the end of this video if you guys didn't see it. It's taken a little longer to edit than we expected, but here's the scheduling plan. Friday, we're planning on playing the golf video, the 250K celebration. Saturday, we're planning on playing the day in the life video. So stay tuned, coming very soon. Again, subscribe, hit the bell, all those things. Bodie, is there anything the defendant can't say when he testifies? Besides, like the Darrell Brooks stuff, like there's some stuff, there are some limitations, but he can say, I wasn't there, I was on the moon. He can say, your mom did it or whatever, even he can be disrespectful. They can joke around, whatever. They have a lot of leeway when they're on the stand, but the jury is sitting there listening, watching, taking notes, and making the ultimate decision. So you got to be careful. Shelly, can he insert an alibi later on? So that's where the may comes in. So yes, he can by his own testimony. Yes, he can by cross-examining witnesses. And he may even be allowed to produce witnesses and testimony of an alibi later if the court allows it. Now, if the court finds the defense is playing games, it's fake, they made this up, they had this information or should have had this information at this time, he can exclude it. But I think if they said the neighbor finally came forward, we couldn't get a hold of him, judge, they weren't responding to our calls, they finally responded to our calls, his next door neighbor in the apartment, they saw him there the whole time, they can hear him through the wall, whatever it may be, they just came forward, the judge should allow that. In the interest of justice, the judge should allow that, and my bet would be he would, which again, makes some of these deadlines much ado about nothing or nothing burgers because he still could come up with one later. It's unlikely now. I will say it's a lot less likely that he has an alibi other than his own testimony now than he did 24 hours ago. Run this world. Whoops. Run the world. The murders happened right after Halloween. If there wasn't any other DNA, do you think he could say he went to a costume party and he went into the house and dropped the sheath? Sure, he could. And, if they have pictures or social media posts of a big Halloween party, a lot of people there as hunters or, superheroes or whatever. I don't know what superhero has like a little knife and sheath, but he could. Yes, he could say that. Patrick, did they use lawful law and exhibitees? Not yet, Patrick. Not yet. Channeling the heart, Barbara Joyce. Could Lori VD claim alibi? She did. She did file a notice of alibi. It did not work in getting her off, but she did file a notice of alibi and still lost. So just because you file a notice of alibi, just because you say you have evidence of an alibi, just because somebody testifies and says, hey, he wasn't there, then that doesn't mean you're actually not guilty. It doesn't mean you're going to win. All right. I've got about 5 more minutes here for some questions. If anybody has any more questions. I'm going to do 5 minutes of questions. Then I'm going to announce the winners of the merch. Some of it signed, some of it exclusive to the 250K giveaway. Can't get it at other times or places. But I'm going to search for some questions here for a minute. Freelance Kate, in most other cases like this, they find lots of DNA, don't they, at the crime scene? I don't know if I would say lots, but usually it's not just one piece of touch DNA on the sheath of the weapon they believe was used in the crime. It's very unusual for that. Very unusual. Mel, if he had a proper alibi, he wouldn't be in jail. A lot of people in jail think they have an alibi or file notices of alibi. It's Marie. So if expert witnesses can debunk the phone pings, he could prove that he was not in the area at the time of the murders, right? Yes. If they can look at his pings and say, look, it actually proves he was over here, that could potentially be an alibi. So that's through expert witnesses, which at this point, I don't think the deadline is passed where they have to get all the expert discovery in. So that's why they're allowed to do that later and say, actually, this evidence points that he was over here. So he can still make the argument he was not there. And that's what I think we learned from this notice of alibi, that he doesn't have some specific thing like, again, his wife was laying next to him in bed all night. That would be produced in this notice of alibi. But potentially other arguments could still be coming. All right, let's see here. Yeah, it's a good question. Jay, Peter, okay, but did they also do the IgG trees for the 3 unknown sources of DNA found at the scene? Again, this is why I think they should get as much information as they possibly can in discovery to flesh all of this stuff out. If you're innocent, you'd have some kind of alibi. Not actually true, right? That would mean anybody that lives by themselves could never be innocent. Because if you live at home by yourself and a murder or a crime occurs at night, how are you going to prove that you weren't there outside of your own statement? Brooklyn Basement. BOIO released on 11/25. BK and his car. Oh, is that Bolo? BK and his car identified on 11/27, but car's year was wrong. Is it sus if the IgG tree was created after 11/27? I don't know if I would say it was sus. It's sus, but I think that if it was created before, it would make it even very difficult to say that they had the DNA to plant, right? Like some of the questions are right now. Chojo, Peter, is lawful law a real word? It's a real word. It's not a real legal argument. Peter, please cover Ellen Greenberg case. So here's what I want. When you guys hear stuff like this and you see a case name pop up, if you are also interested in it, let me know in the chat. Let me know in DMs. And that's how we will continue to pick up steam and realize that there's enough interest, that enough people would be interested and engaged and involved in being educated and helping educate us and having your opinion involved in the case. That's the only cases I want to cover, are the ones you guys are all interested in and want to be a part of. So if you see a case name like this pop up and you're also interested, let me know in the chat. Shelly, Peter, what do you think is the likelihood of him providing testimony in court? See, I don't know. I don't know yet. I don't know. I feel like he would want to, but as how it's been going so far in the case, it would indicate he's not going to. But I don't know. I don't know. And I feel like a lot of people on the outside and a lot of the public are like, oh, there's not enough evidence. They can't prove it. There's just nothing here. It's just touch DNA. So if the defense kind of agrees with that and they think the state doesn't have enough to prove this case, then he's not going to testify. Selena, how unusual is it that convictions can be made on circumstantial evidence alone or only? It's actually very common for cases to go to trial on circumstantial evidence and people to get convicted, but not all circumstantial evidence is equal. Angie, Peter, is it normal that he did not file an alibi, or do you think the defense is stalling? I don't think they're stalling. I think he just doesn't have a traditional alibi, like I've been kind of explaining. Ashley, isn't it crazy how much more info we have on Rex, the Long Island case versus BK? Yes, that case has been around for, 13 years. But that seems to be a mountain of evidence. Burning Queen, is it possible that the state has definitive proof proving Bryan was there the night of the crime? We hear there is not DNA in his car, but could the state be holding on to the DNA they actually found? Well, they could be holding on to a lot of things because, as Ashley just mentioned, we don't know a lot in this case. There's a gag order. There's hearings that are happening under seal, filings that are happening under seal. So I will never say never on this case. because there's just so much we don't know. All right. So if you guys have more questions, we can keep throwing them in there, but I'm going to now put up the winners of the 250K giveaway, and we can run through these. John will post in the chat the link for this. So if you go to the lawyeryouknow.com page and you click 250K celebration, it will pull you up to this, and you can kind of see each individual item and who won it. The Peter socks was Gloria, autographed Adidas polo, large gray. Ashley. Oh, Ashley's been in the chat a couple times tonight. You are a winner. Congratulations. Paul won an autographed polo. Olive, Lucas, Aaron, one. It's elementary large shirt. What's up, everybody? Shirts. Cassie, Anya, Tammy, Jen, Christina, Alexa, Mary. What's up? Water bottle by one by Beth Jackson. Words Matter notebook by Kimmer Patton. And then the 250K limited edition premium t-shirt that is really only going to be available for this giveaway. We're going to pull it off the site. So not a lot of people are going to have these. Anna, Lynn, Tammy. Did Tammy win twice? No, two different Tammys. If your name's Tammy, you got a good chance at winning. Laura, Stacy, Aaron, Mikhail, Joanne, and Lisa won the Lawyer You Know hat. So let me see here real quick. Yeah, hit that like button if you haven't already. Here is one of the What's Up Everybody shirts. And then here's the 250K subscriber celebration shirts. They're real nice materials too. So I'm going to sign some of those, get some autograph stuff out just for fun. It's hard to see the autograph on the black shirts. We didn't think about that ahead of time. So I'm going to try to find a spot to autograph them. If you didn't win anything, okay, I see some people saying I never win anything. Well, if you didn't win anything here, some very, very large giveaways are happening Friday during that golf video. So stick around. We're giving away memberships. We're giving away merch. We're doing all sorts of stuff during that golf match. So stick around because this is just the beginning of the giveaways. It feels like it's never going to end after we did that golf video. So that's fun. And I try to do as many giveaways as I can just to keep people engaged and getting stuff and having merch and continuing to have fun with the channel, which is a part of it, which is always difficult with the types of topics we talk about, but we try to keep it light and enjoy the ride as much as we can because we are learning. We're learning about the process. We're learning about our rights. I'm learning what you all think and what jurors potentially think. So I do appreciate that always. All right. So we're going to finish off here with the poll. Almost 2,000 votes. Did you expect Kohberger to produce an alibi? 32% said yes. 68% said no. So most of you are not surprised by the news that Kohberger did not produce an alibi. Somebody said, what time? I think, Liana, of course you count in Canada. Of course our neighbors from up north count. So John is going to send an email to all the winners to confirm your address so we can send it to you. When is it? So I think it's going to be right around 9 p.m. on Friday. We're going to play that 250K celebration, the golf video. So please be there, be in the chat. Let me know if you enjoy it. It is something different. It took a lot of time. And of course you can win something if you're in that chat watching that video that day. So you got to be there to try to win for that. And a little teaser, there is a choose your own adventure element in the video that we have some extra bonus content that we're really only going to play if the people that are in the video watching it, chatting, vote to continue for one additional hole. So stick around for that. A lot going on this week. We'll continue to push forward. Anything that pops up on BK, let me know. And of course, like I said, Taylor Show Business, my first crack at it, posting tonight. on, what's kind of happened so far in trial, but most importantly, talk about the 2 pleas, the 2 trial phases, how the jury works, what the burdens are, how the burdens shift, how many jurors have to agree. All of those questions will be answered on tonight's video. So again, subscribe, hit that reminder bell so you don't miss it. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.